Court is back in session. You may be seated.
Your Honor, last on our list, the City of Waltham versus the Trustees of the Stigmatine Fathers, docket number 18 CV 2385. Parties, please identify themselves for the record.
John Savone, representing the City of Waltham, Your Honor.
All right, good afternoon, welcome, sorry to keep you waiting.
Adam Patton, representing the defendant Stigmatine Fathers.
Good afternoon.
And Peter Flynn representing the Stigmatines as well.
All right, good afternoon. Welcome, have a seat, make yourself comfortable. Okay, so I've reviewed the papers. I'll hear from the plaintiff.
Thank you, Your Honor.
I just want to give this to the clerk on an unrelated matter. Thank you.
And if I may, Your Honor, I know in the last previous cases, I know how the cases that you have, and I know that sometimes the press of business is dealing with all those who are difficult. I have copies of, I heard a question to a prior attorney. I have copies of some of the, not all of the cases cited.
Okay.
In the memorandum.
All right, thank you.
Many of the
You have a copy
salient
to the other
ones.
side too?
They've already been cited. I don't have copies of the cases. They've already been given the memo, Your Honor.
Okay, thank you. So the land court does not have jurisdiction of a case like this?
They would, Your
Oh,
Honor.
they did?
They would have concurrent, yes.
Oh, okay.
In all candor, they would.
All right.
But I don't know that they would have the ability to grant the, all of the injunctive relief that we're talking about. So,
Your Honor, I hate to interrupt, but an eminent domain case, exclusive jurisdiction is in the Superior Court.
Okay. Go ahead.
fine, Your Honor. The real issue here is about the growing school population in a working class town, which has a system-wide student population of 5,600 and growing. So this, for a moment, I will leave the legalistic areas for a moment. And that's really what this is
I
about.
guess I want to challenge you a little bit on that.
Yes.
Why is that the real issue? Why isn't this a technical legal issue? I mean, obviously, if that's the real issue, that favors you.
Well,
How is it that such a broad policy issue is put into the hands of the Superior Court? That's unusual.
yes and no, Your Honor. The case, one of the key cases, and it's in one of the copies in there, is LeClaire versus Town of Norway. And it's almost squarely on point in this issue. And it literally says that the issues of new school construction in Massachusetts and MSBA funding of these projects are matters of special public interest. It's on the last page of the opinion, Your Honor. Even though the court found, this is the SJC, even though the court found in that case that the town violated the public bidding and design and selection laws, they would not grant the 10 taxpayers' request for injunctive or other relief that might stall or jeopardize the MSBA funding. And I'll quote from the very last paragraph of the SJC opinion. Balancing the equities, it's apparent the public interest would not be served by entering an injunction for the purpose of the design and selection statute, and that statute and the town bylaw to create integrity in the design and procurement system.
You're reading from what? From what, a tab? Or from your?
No, I'm reading from one of the cases that's in there, LeClaire versus Town of Norway. It should be under public interest, schools, matters of special public interest.
I think I think I need to display this to opposing counsel just so that they see what I've been handed. I've been handed folders by topic, so let's show these to defense counsel. They're entitled to see what I'm seeing. I'm perfectly willing to look at it, but I do want defense counsel to be aware. I mean, you probably want to look at just the headings.
Your Honor, we're familiar with the gist of
All right.
Attorney Simone's document.
All right. You were saying?
So the SJC, and this has been well established, despite the fact that the SJC acknowledged that the public bidding and design selection laws were violated, they said the special public interest in not delaying school construction, design and construction, and not jeopardizing Mass School Building Authority funding outweighs that.
Okay.
And quoting from the last paragraph, to enter a preliminary injunction would halt an important school construction project without benefiting the public goal of fair and equitable design and procurement system. And they mentioned specifically, entering such an injunction would do serious damage to the interests of the public. By delaying design or service contract, the town will likely be excluded from the priority list for state funding for school construction. If an injunction were entered, the town would lose or delay receipt of substantial grant funding, potentially delaying school construction and increasing design and construction costs. That's exactly what is happening here, because notwithstanding the Chapter 79 says upon the recording of the taking order, the title vests, and notwithstanding that Chapter 79, Section 3, which is attached to the back of my memo, says they are prohibited from interfering with our access. They are, in fact, delaying construction because, as the affidavits from architect Lorraine Finnegan indicate, the residents of the site, a few buildings, there are 4 resident priests according to the Exhibit 5 in the memo that was statements from the president and director of their corporation. They have hired private security to prevent our architects, surveyors, engineers from entering the property to do preliminary site surveys and other work on the outside portions of this 46 acres. No one has ever said that they're going to go in the buildings or remove or displace anyone from the buildings. But apparently, the interpretation is that all 46 acres are solely under the control of the defendant, even though the taking order has been recorded July 23rd, and Chapter 79, Section 3 says we have a right to uninterrupted possession.
So why do you need anything from me in terms of, you have an order that you own the property?
We have recorded an order of taking in the Registry of Deeds.
And what does that mean?
Under the,
court judge, you know, apparently
Yes,
they don't
sir.
have jurisdiction.
under the statutes, that
Does that
best
mean you
title,
own the property?
that best legal title in the city.
So why do you need anything from the court on that sub-issue?
Because contrary to Section 3 of Chapter 79, the defendant is hired security to block the front entrance and prohibit.
Why not call the police?
The police consider it a civil matter. They're waiting for the court to resolve this because everyone knows that we have this hearing scheduled.
Is the taking order in this document,
Yes,
It must be. Here
yes,
it is.
it's Exhibit 1 to the memo.
I mean, obviously, no court has enjoined this order or stayed it, right?
Correct.
Okay.
So when we next go to Section 3, which talks about once the taking order is recorded, and it says, upon recording of an order taking, title of the fee shall, to the property taken or to such other interest, shall vest in the body, politic, or corporate on behalf of whose interest the taking was made. Next paragraph. If the person in possession of the property which has been taken in fee refuses to permit the body corporate by which the taking was made to enter thereon and take possession or exercise his rights, then the body, politic, and corporate may seek a warrant for directing the allowance of the city, in this case, to enter the property. They have totally ignored that, claiming that another section that talks about displacement from dwellings or businesses allows them to control all 46 acres and prevent our surveyors and any other of our school technical and consultant people from entering the property to do wetlands or normal surveying of the property. Clearly, and the necessity is really something that the Mass School Building Authority acknowledges. We have a 50-year-old high school. Their regulations acknowledge that 50 years is the end of the useful life. And in this particular situation, this new high school project is really the foundation for the system-wide expansion of the schools that the MSBA has noted is needed. Because once we can build the school, the full high school at this site, then they can renovate the old high school for the increased middle school population and some grammar school. And because we have a fairly high minority population in Waltham, there are additional language learning and other CVTE programs that need new space.
So I want to talk about the money issue.
Yes, sure. And just before the Atkinson Act, the other important aspect of this is the MSBA and the superintendent, Drew Eccleston's affidavit. It attaches documents including amendments to the contract with MSBA that basically tell us that we have to have the site selection established by September 30th, 2018, which I think is another reason why the defendant has tried to interfere with that. And it's key. They sent a letter, July 18th, the defendant sent a letter to the MSBA trying to interfere with our contract and threatening to sue the MSBA itself if they proceed with the funding, the current funding agreement with the city of Waltham. So the issues here, because that involves potentially 150 million plus in benefits, school construction benefits to the city of Waltham, it affects not only the ability of all our school children to have appropriate facilities, but it affects the taxpayers, because if that funding is jeopardized, as the Leclerc Town of Norwell case mentioned, we will, as the attachments to the affidavit indicate, we will probably lose the current budget cycle with MSBA, and it will clearly delay it and increase construction and other costs. In fact, the July 18th letter from defendant's attorney to the MSBA even acknowledges all that. That letter, the July 18th letter, which is Exhibit 1B, I believe, to the memorandum, basically makes out the case of interference with our advantageous contractual relations with the MSBA. On the money issue, and I apologize, that may, and if I may just for a moment, what's really interesting is the defendant's motto and charism states one of their key things is they're dedicated to the instruction of use, and their pastoral characteristic is mobility. It leads us to avoid staying fixed in activities or regions, but it appears that they hope to sabotage the school funding agreement with the MSBA in mistaken belief that we will
You
go
might want to
with-
save that argument for a jury.
Yes, sure. With regard to the money, Section 8A, it's the last section of the memo. It's statutory construction. If the legislature says something, but doesn't say something else, it implies that what was not said was designed, was intended to be purposeful. So if you look at Section 8A, which is what they are based much of their claim on, it says the pro tanto, if demanded and paid, is not exclusive of their right to seek further damages, but it doesn't acknowledge that the demand for pro tanto allows them to continue the validity of their taking. And importantly,
This statute you're referring to, where did you say you put it in this book?
Chapter 79, Section 8A,
And there's a copy here.
I believe so, but I have another one. Chapter
I have it
79.
right behind me too.
Chapter 79, Section 41. It says, if no petition under Section 14 is filed within the time limit, the award of damages will be final, and then the amount thereof shall be paid on demand. So obviously,
What section is it, 79?
79, Section 41 and 8A. So there is, I did not enclose
I got it here.
Section 41, nor did I enclose City of Preston versus City of Newton. But that section and the case indicate that obviously when you're talking about, if they're only talking about claiming more damages than what was awarded, they can proceed and they're entitled to claim the pro tanto. But that Section 8A doesn't also say they get the pro tanto if they're also claiming that they still own the property because the taking was invalid, which is exactly what they're doing. So we're talking about them claiming they're denying us access to the site after we've recorded the order of taking. They're claiming that they own it because the taking was invalid. They're a subsidiary of they're a Massachusetts holding corporation for a foreign entity.
You're talking about 79, Section 8A?
Yes, that's
I'm
what they.
behind you, basically. You're ahead of me a little.
Oh, I'm sorry.
That's what it was me.
But related to that,
Okay, so what were you saying?
so when 8A does not also say they're entitled to get, they can go forward and get it when they're also claiming validity. It only says that they can do so when they are seeking damages.
When
the
they're
cases that I-
conceding the validity, but saying the number is wrong.
Yeah, correct. And I told them, if all we were doing, we would have had no problem. And we asked them to agree to some sort of an escrow or Rule 67, and I did attach in that package is a similar case where under Rule 67, a Chapter 79 award was placed in Rule 67 holding in Superior Court pending final disposition of the case.
Well, so are they gonna say in a second that they wish to accept the offer as a pro tanto payment, but wish to contest the amount?
Yes,
So why aren't they entitled to do that?
but they would be if they weren't also claiming and acting it out.
Where
Acting,
does
they
it
still
say
own
that?
ownership.
Where does it say what you're about to say in the statute? It doesn't say that.
It doesn't say that, but that's where the statutory construction argument at the back, final portions of the brief says it. Because it says in 8A, they're entitled to get the pro tanto, but still go forward to assess damages. It doesn't say they're entitled to pro tanto and go forward to contest validity of the
It
taking.
may be a waiver by them.
I have, that was my position, but they're claiming that they're gonna still contest our right to access the property, and they're still gonna contest the validity of the taking and potentially sue the MSBA
No, but
because they claim ownership.
maybe it's a waiver of the ability to contest the validity of the taking.
I understand, Your Honor, that is part of what we're saying, based on Section 8A and based on Section 41 of Chapter 79, in that Preston versus Newton case.
All right, so what else do you want to say?
Because they are a foreign entity, and as the attachments demonstrate, this money will be going to Rome in the unusual situation that this gets contested, they continue to contest validity, continue to claim ownership and deny us access to the property. We'd be in the position of basically paying them $18 million to go to Rome, to have the money sent to Rome, while we still don't have access to the property and they're not leaving.
Those are separate issues, access and what happens to the money.
Well, in a sense, Your Honor, but if they're also, as the cases on interference with contractual and advantageous relations relate to, their own letter in July 18th of 2018, they have acknowledged that it will cost us significant increased damages by these delays. We would have no way, there'll be no security for us to, if they continue this needless delay, there'd be no security for us to obtain any security for the payment of those damages. There will be nothing, they have nothing
So
in the
let's say
state.
you are able to get onto the property immediately, will you have any damages?
If they continue to contest the validity and interfere with the
Well, what if they have
contract,
no ability to physically interfere with your ability to access the property? Will you have damages going forward?
it depends if they interfere with the MSBA agreement. If they continue to claim ownership and interfere with the MSBA agreement, yeah, we will have damages, Your Honor.
Will they have a right of access to the courts? That's-
Yes. Yeah.
Anything else you want to say?
Well, Your Honor, just on the issue of their claim, they've been claiming they're going to sue for validity. They're claiming, part of their claim is they have 3 years to contest validity, during which period they have the right, since they still claim to own it, to be there. That's totally inconsistent with our ability
So
to build a
what's their
school.
argument going to be as to why they can control physical access?
Because they said the statute of limitations in Chapter 79 is a 3-year statute. But as both, there are 2 cases that I cite. One is Town of Chelmsford DiBiase. That was a Chapter 79 case where the town brought a declaratory judgment action just like this to clear the title because the defendant was claiming no validity. So clearly, the SJC says they don't have those 3 years, but
All right.
they're continuing to do that.
All right, so let's hear the opposition. Or is there something you wanted to add about, not something that I'd asked about?
If I might, we would also like to have, just on the issue of the validity, since they've never, there's no apposite case law or facts, they just make allegations, which the HTA case says is wholly inadequate. We would like an accelerated summary judgment schedule just on the issue of, since they have the burden.
All right,
Proving
well,
validity.
if I forget to address that, remind me.
Thank you.
All right, I'll hear the opposition.
Thank you, Your Honor. Your Honor, I'm going to move along very quickly. I watched it, he started at 20 past, so we went about 22 minutes.
This is the only courtroom that I can remember in more than 17 years in which the judge does not have the best view of the clock.
I've got 2 of them here, Your Honor, plus my watch. I was watching. What I'm trying to say, Your Honor, I'm going to move quickly, and I hope what I say resonates, and I'll try to get through this and see if we can break it into.
Maybe I should ask you a question or two.
That would be, that's your prerogative.
What's your legal authority to prevent access to the site, just in terms of being practical?
All right, Your Honor, let me jump ahead to that. And I will just say this. even assuming that the city's position on the access was, and the taking was valid, in that situation, the landowner is, when they make the claim that they cannot, we cannot prohibit access, that's dead wrong. Because we have, once they made their taking on July 23rd, because it's an improved parcel, Your Honor, it has buildings, we have 120 days automatically to exclusive possession of the property. They don't have.
From what? So where's that, is that a statute? Where do you get that 120 days?
Yes, Your Honor.
Do you have a site? So this order is dated July 19, 2018, is that?
It's July 23rd, it was recorded.
Okay.
General Law 79, Section 8B provides that the landowner may continue to occupy the property after the taking. And I'm going to be very specific, Your Honor. In the case of an improved lot, which this is, the 46 acres has about 6 or 7 buildings on it. If it's being used as a resident, or a business, such as in this instant case, then the tenants are entitled to 120 days possession. If the lots were vacant, which they're not, the landowner would only be entitled to 30 days. That would have brought it from July 23rd to August 23rd. In this situation, the reason the 46-acre parcel is one unified lot is...
Bear with me, let me just read this short statute, and then I'll ask you to continue. Bear with me.
Okay, Your Honor, even if portions of the parcel do not contain buildings, they've already stipulated in their order of taking, there's no dispute, that this property, the 46 acres, was formerly separate parcels of land, but it's now known by their own title exam, it's known collectively as 554 Lexington Street, containing 46 acres. Therefore, the defendant, because it is an improved parcel, is entitled to exclusive use and occupancy for the entire 120-day period stated in the statute, if not longer, because of the fact they have denied us relocation benefits and haven't even done anything with respect to relocation.
Where does it say exclusive use and occupancy?
It's just, what we're saying, Your Honor, is that if you have 120 days, it's like this, Your Honor. Think of it as a...
I'm going to put it to you tighter than that. This says you can't be made to vacate.
That's right.
But do you have a case or
Well,
something that says exclusive right to occupancy that you can block the gate?
It's a simple landlord-tenant situation, Your Honor. If I give you like an order of taking, says you've got 30 days to get out or 120 days to get out, if I'm a landlord and I give you 30 days to get out, and the next day I show up and say, hey, by the way, you can get out of the apartment because we're going to start painting it for the people coming in.
That sounds like a different situation to me.
It sounds like...
It sounds like a different situation to me.
Well, Your Honor, they're trying to take control of the property, the entire property.
Do you have any other legal argument on why you could block the gate?
We're entitled to 120 days of possession, and they should not be on the
Section
property.
8B. You're relying on 8B.
Correct. One of the things, Your Honor, here is that it's a traditional tenant situation. They're coming in, they want to use drones for digging, borings, paint markings, and that is not sustainable. However, Your Honor, let me, if I may, go back. There are 3 things in front of the court today. 1, the city's illegal request to control or attach the pro tanto award. 2, the city's request to access the landowner's property to test, survey, drill, and even use drones. City request to prohibit contact with the MSBA. Our position is that they cannot prevail on any of this, Your Honor. Much of the city's memorandum of law that you have in front of you, Your Honor, is request for injunctive relief is aimed at arguing the merits of a yet-to-be-filed challenge of the validity of taking. That issue is not before the court. That's what they're talking about here, and it's not in front of the court. This isn't a 12B6 hearing. This isn't summary judgment. This isn't anything like that. They're talking about anticipatory what they're anticipating we're going to be doing, and that's going to be.
You may be completely right, but I'm gonna warn you that we move fast on that as a public importance. So, tell your client or clients.
I understand that portion of it, Your Honor. However, General Law 79 requires that payment be made to the property owner on a pro tanto, and it requires the taking authority to make prompt payment of that amount. They've got the 15 days because we made a demand on it. When we made the demand, I want you to know this, Your Honor. This is the duplicity of what we're facing here. What happened here, Your Honor, is they were going to pay the pro tanto. And on Wednesday the 15th, there was no doubt that that was going to be paid. And on the 17th, I extended it to the 20th, to that Monday. I got an email on the 17th saying, can you send us the ID, the tax ID numbers of the Stigmatines, both federal and state? They weren't aware. They said, you do more than this than we do. There's some things you gotta give us. So I actually filled out a W-9 and sent it along to them on Friday morning. Supposed to get the pro tanto check on Monday. I show up Monday at the city hall. I brought out the mayor. You'd think a terrorist was in the building. I'm sitting there looking for my pro tanto check, Your Honor. I've been doing this for 40 years, and they've asked for a federal ID number. They bring me out in the hall, and they said, oh, by the way, we sued you Friday afternoon. I didn't know that. I had absolutely no idea they had done that. Now, no other statute authorizes the taking authority to withhold the pro tanto award because the landowner has filed suit challenging the validity of the taking and/or the amount of damages awarded. Payment cannot be withheld because the taking authority believes that a landowner might file such an action. We have not filed that action, Your Honor.
So
This
as
is.
trustees,
What's that?
are you gonna close your entity and move overseas?
No, that's preposterous, Your Honor. I have the
But
lawyer.
that's the suggestion.
Yeah, that's absolutely. They own 400 acres in western Massachusetts, the Stigmatines. Let me give you an example, Your Honor. What happens when they.
Here's an unfair question.
No,
Right?
it'll be fair.
This is an unfair question. Does your client concede the legal authority over the $18 million even if it's paid to your client by court order?
Do we concede?
So what if the court orders that the money be, the $18 million be paid to you,
Correct.
and then there's a problem in the legal process and it's determined that the $18 million should not have been paid to you? Is your client going to surrender if the court orders it?
Absolutely.
Well, what if everybody's in Italy?
Well, here's the problem with that, Your Honor. What happens if I came in tomorrow? If I came in tomorrow and said, listen, I have the best experts in this part of the country for the eminent domain case, and they want to pay us $18 million, and I know I'm going to get a verdict of at least $48 to $52 million, so I want you to right now issue an order making them appropriate or set aside $30 million in that event. You know what they would say to that? Oh, no, because if you get hit for that amount and we don't pay you, we'll have to pay you. It's the same argument for the Stigmatines. The adjustment has to be made. I have that, Your Honor. If I could get through this. There is no reported case, Your Honor, which is in which authorizes a city to withhold a pro tanto payment because the property owner has indicated the taking was not valid. To do so would result in a situation which the landowners who have not disclosed or disclosed their desire to challenge the validity or even think. If you make the statement, well, we're going to challenge the validity, they think they can then turn around and withhold a pro tanto is what they're doing here. We had 3 years from July 23rd, Your Honor. Once they filed that order of taking, they were supposed to pay that pro tanto within 15 days. And we had 3 years from the date of the taking to challenge the validity or challenge the amount of damages or challenge both together in alternative in the Superior Court. We could challenge the validity first, which would be heard first by you, Your Honor. Failing that, we would then go to the issue of damages. We have we have clean hands. They've taken this property against our will. Now they're trying to play around with the pro tanto. We have never seen that. I've never seen it in 40 years of doing this, Your Honor. And I really hope, I know a lot of stuff is anecdotal, but I hope you look at the affidavit of Chris Quinn. It's in here. Your Honor, Chris Quinn stands pretty much in my shoes. I was a special assistant attorney general under every attorney general since Frank Bellotti doing eminent domain cases, reviewing orders of taking. And I said, if I go to court and just say that, and I don't have a backup, I got a problem. His affidavit, Chris Quinn virtually ran the Department of Transportation Right-of-Way Division, and he's on an affidavit in this case. And he, like myself, is saying, this is utterly ridiculous. In the 35 years as a special assistant assigned there, and me doing it for the same period of time, we're looking at this, and it's just never been done. Withholding of a pro tanto to use as leverage. It's absolutely unconscionable, Your Honor, how they're trying to handle that.
So what else do you want to tell me?
Would you just give me a few minutes,
Take
Your
your
Honor?
time.
We have a proposed order. I'm watching my time. So, Your Honor, let me slow down for a minute.
Where's the proposed order?
At the end of my
I see it.
submission. Your Honor, seriously, the taking authority cannot try to eliminate the landowner's legal options of gaining leverage by refusing to pay a pro tanto. That, you simply cannot do that. You can't just come in and try to have it both ways, where you take the power of eminent domain and then refuse to issue the payment. They want to get on the property to do testing, and they're refusing to pay the pro tanto. We have never seen that ever, Your Honor. We're not required, Your Honor, by the way, to choose one or the other. We don't have to choose validity and damages. We can do both simultaneous, and that's in the Ramondi case, and there's no dispute about that. If the court were to rule, Your Honor, that the taking was invalid, the court would also rule that the landowner is required to return any payment received from the taking authority. Your Honor, in front of
And
this court.
your client will respect that order no matter where the assets are located.
Exactly, and the defendant acknowledges that obligation.
Okay.
The 79 provides for refunds where the verdict is below the pro tanto, and it doesn't set a limit on that. And there's no difference between a refund on a lower land damage case or if a pro tanto has to be returned if the taking was invalid. In either case, Your Honor, there's no doubt that a financial adjustment has to be made, and it will be made, and the Stigmatines do that. Now, I want to address this, Your Honor. Just give me a couple of minutes. Chapter 79, okay, has it there, right there, and it's in our memo, and you can look at the text as well. Where can a taking authority withhold a pro tanto? They can do it, one, where title of the
What
property.
section? I have this statute in front of me. What section am I looking
79, section 7H, and 79. And just so it will resonate, where title to the property is unconfirmed, or there are valid liens against the title, if, for instance, they didn't pay their water bills. And when taxes are due, the Stigmatines are actually tax exempt, so that wouldn't apply. And they're not making the claim that any of these apply. And also, if the landowner is unknown or under a legal disability. Your Honor, if the legislature were considering any examples when you use the most hostile, most surgically powerful thing on earth, eminent domain against an innocent landowner, they would have spelled it out that you could withhold under other circumstances. That's why they give the landowner 3 years to attack the validity and go after the damages, because they are stuck in the position of being displaced. Now, the requirements on the affidavit, Your Honor, from Christopher Quinn, I might add this, okay? And I promise I'll finish up in a minute. Approximately 95% of all the takings are done by the Department of Transportation. That's the agency that he worked for and that I've represented for many years. And when you look at the affidavit in conjunction with the 40 years I've been doing it, I think it would be totally unfair to ever enter the world of doing anything except ordering the city to pay the pro tanto. The Stigmatines, Your Honor, were incorporated in 1918. They've been around for 100 years. They've been around a long time. They're an honorable group of people. They've got a gift shop, residence, meeting rooms, religious shrines, open space in them. Your Honor, let me report this to you. They have done nothing to relocate the Stigmatines, which is the first requirement under the statute 79A, that before you even make your taking, you have to come and lay out a relocation program for the Stigmatines, and that has not been done. And now they want to get on the property when they haven't even done the first step, the relocation. That goes back prior to the taking back in May and June. And the other issue, no access should be allowed on the property, Your Honor, without that entire pro tanto amount being tendered. The first obligation of the taking authority, other than proper relocation benefits being established before the vote of the taking, is you got to pay the pro tanto, and they have not done that. And I will end with this, in that we have never seen this, because this action that is before you is actually brought under General Law 231A. It makes us, do you believe this? It's made us the defendants. We've been there 100 years, Your Honor, and they've come along and they're trying to displace us. And they're going through every procedure, and they're breaking all the rules. And now they're making it look like we're gonna do, that we've done something wrong. All of this stuff about validity of the taking, they've put that in issue. We haven't brought that to the court yet, and we have every right in the world to do that. And the poison the well approach by what they're doing here is just unconscionable. Now I'm on my final argument. I promise you, Your Honor. The argument that the Stigmatine fathers or their counsel cannot contact the MSBA simply has no legal support at all, because there are citizens that go to this shrine all the time. They are taxpayers in Waltham, and they are appalled at what's going on down there in Waltham. They have every right to write to anybody they want. They could call the President of the United States tomorrow and say, listen, MSBA. They could call state rep. They could call the Department of Education. They can call the MSBA and say to the MSBA, hey, do you know what's going on up there? They're not doing the right thing by the Stigmatines. They're not giving them a relocation. Their appraisals are all, we don't even know if they have proper appraisals. And if you're going to lend them $150 million, you ought to know that they're not doing things right up there. And if they're not handling the Stigmatines or giving them a place to relocate, you better be very careful about how you lend money. And if you're going to lend them money, and Your Honor, I know that you're not going to disrupt who we can talk to and who we cannot talk to. They don't have a contract with the MSBA. They're trying to get one. And what we're telling the MSBA is be careful on how you spend your money, because there is a problem here, and this taking may be declared invalid. In any event, they are not doing right. As a matter of fact, Your Honor, I'll end with this. When we leave here today or tomorrow, it would be our intent to contact the MSBA. We're trying to set up a meeting with them, and we will invite the mayor, everybody in that room, and the city solicitor to join us. And if they would like to be heard by the MSBA, we will invite them, and we promise we will do that. Your Honor, we have a proposed order, and I understand the competing interests here. I really do. But this pro tanto thing is off limits, and thank you for the extra 6 minutes.
So talk to me again about, well, you wanted to add something?
Oh, yes.
I'd like to add something. I heard Mr. Savone refer to the Stigmatines. The Trustees of the Stigmatine Fathers, Inc. as a foreign entity. It is a Massachusetts church corporation incorporated in 1918. They are not simply a real estate holding company, as he referred. They are an active religious order holding retreats and seminars, and it's also the home for the retired priests who are receiving medical care. So it's simply not as he's portrayed it. Further, Your Honor, as Mr. Flynn has said, this is a case with an odd posture where the taking authority has sued the landowner and put in issue the validity of the taking. And from the city's pleadings, it looks like they've done so because of some well-grounded fear that we're going to attack the validity of the taking. But in reality, Your Honor, this has been a very messy process. It's had many controversial twists and turns, many of which have been reported in the press. And I believe that the city has grave doubts about the validity of the taking that they implemented, and that is the reason why they're trying to clear the area. With that in mind, it seems appropriate to preserve the status quo, exclusive possession by the Stigmatines, until this matter can be heard. And certainly we would want the opportunity to present evidence to counter the city's claim of valid taking. And further, Your Honor, the urgency which the city stresses to the court here is an urgency of their own making. This threat to take and various other forms of attempted acquisition of this property has been going on for almost 3 years by the city. And so it seems to me to be disingenuous to conduct or to enact a taking in July and then say, look, we've got this hard September deadline that we're going to lose everything unless we can proceed full steam ahead. And all we ask is the opportunity to be heard on the merits. Thank you.
Thank you. Thank you.
If I may, Your Honor, just, it may relate to a question you had asked that I don't think was fully answered. 8B talks about they can't be required to vacate a portion of such property which is being used by him as a dwelling place or place of business. They're only dwelling in the building. They have one structure that they have 4 resident priests in, according to the statements given by Father White, and they have a gift shop. No one's threatening to remove them, which goes back that there's a lot of talk about this red herring about relocation. They've refused. We've given them the name of the relocation expert we've hired. They've refused because they're demanding to remain on the property. We had been willing to let them stay on the property. We're willing to let them do it rent-free for a period of up to a year. There's never any, we've been negotiating, we had a deal that they broke. It's one thing after another, Your Honor. And the claim by Attorney Flynn that he was totally surprised.
So your position is that if, for example, I should order opening up the property and someone should fall and injure themselves, then the owner of the property is the plaintiff and not the
Correct.
defendant. And the owner of the property is the defendant in the lawsuit. Is that a fair statement?
Oh, well, you mean if someone were to fall, Your Honor?
Right.
Yes, absolutely.
But let's say I order it opened up, someone falls because of a ditch
Yes,
that you didn't cover or warn.
correct.
The entity that gets sued is the plaintiff in this case.
Absolutely.
Not the I'll call them, not the
Corporation.
corporation, right?
That's correct, Your Honor. Absolutely. Which is part of why we have, again, we don't plan to take them and remove them. We've never given them an order to
So whatever you do,
placement.
you insure or self-insure
Yes.
or whatever, right? I don't even know, right?
Correct.
Okay.
Your Honor,
Now,
if-
so on that subject, access to the property, did you want to say 4 or 5 sentences and have the
Yeah.
last word?
It'll be less than that, Your Honor. If you're gonna order that they are gonna be allowed on the property to test, I would hope it would be within reasonable hours, during business hours. We do use the whole site. If you do order that, it's got to come with the payment of the pro tanto. We have to have that pro tanto.
I'm gonna need time to figure out the pro tanto issue. We do not deal with an eminent domain that much. I'm gonna need time for that. Okay?
And again, Your Honor, just,
No, you don't get to go back and forth.
oh, yes,
Unlimited amount
sir.
of
Sorry,
time.
sorry.
You've had a reasonable opportunity.
Thank
I
you.
order the property opened up for reasonable access. Okay? So they're gonna be allowed reasonable access forthwith to the property. I expect plaintiff's counsel to have some supervisory role to make sure that good judgment is used. The only way you may fail to comply with my order is if you appeal to the Supreme Judicial Court or the Appeals Court, okay?
Yes, Your Honor, how soon will you make a ruling on the pro
I'm
tanto?
gonna do it as fast as I can, but it's a complicated issue. I will take that as polite pressure to decide fast,
Thank
okay?
you.
But you're gonna open that up unless you appeal immediately. Have a great day.
I appreciate your time, Your Honor. Thank you.
All rise. Go to recess.